Welcome, everyone, to the University of New Mexico Law and Mental Health Didactic Series, hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences, along with the New Mexico Behavioral Health Services Division. We're so glad to have all of you joining us today. I'm Anthony Perillo, the Forensic Psychology Training Director here in the Division of Forensic Behavioral Sciences in the University of New Mexico's Department of Psychiatry and Behavioral Sciences. For our talk today, if you have any questions for our presenters, make sure you enter them in the Q&A box whenever you feel comfortable, but do know that we hold on to questions until the end of the presentation. We do always try to get to as many as we can. It's not always possible to get to all of them, so just forgive us if we don't get to yours. If you are pursuing continuing medical education credits, there will be a sign-in sheet that's in the chat box shortly. And for those of you that are pursuing APA continuing education credits, that will be posted later on during the presentation. Make sure you save your certificate after you open the survey, because we don't have access to your completed certificates after you complete the survey for your CE credits. A recording link and the PowerPoint slides for this talk will be available to you sometime later this week. And as a heads up for next week's talk in the series, we have Dr. Robin Wilson, who will be discussing responding to persons with special needs in forensic settings. But let's get back to this week. I'd like to introduce you to today's speakers who will be discussing competency evaluations across linguistic discrepancies. This is Dr. Rebecca Weiss and Miriam Woodruff. Dr. Rebecca Weiss is an associate professor at John Jay College of Criminal Justice and the Graduate Center of the City University of New York. Her research relates to assessment across linguistic and cultural barriers. She's collaborated with numerous hospitals, including Bellevue Hospital, Mid-Hudson Forensic Psychiatric Center, and Kirby Psychiatric Center. She's also a licensed psychologist in New York, where she conducts forensic psychology evaluations. Miriam Woodruff is a fifth-year clinical psychology Ph.D. candidate at John Jay College of Criminal Justice in the City University of New York. Her research examines how culture and language characteristics impact psychological assessment, with the goal of providing more guidance for psychologists evaluating multilingual people. She's a pediatric neuropsychology extern at Columbia University Medical Center currently, and has clinical experience in criminal and civil forensic evaluations. So Rebecca, Miriam, on behalf of the University of New Mexico, thank you so much for joining our series. We're excited to have you and appreciate you sharing your expertise and the direct work that you've been doing in this area with us. I will go ahead and throw it over to both of you.
Thank you so much, and thank you for having us. It's really an honor to be here. This is such a wonderful series. I do want to acknowledge I have been sick recently. I'm still trying to kick that, and so I am trying my best not to cough into the microphone. So this is for CE credit. We can't answer those questions, but I'm sure they will be answered for you. But we have nothing to disclose relating to this topic, and the views we are expressing are our own and not associated with the University of New Mexico. So again, because this is a CE credit, then we have very specific learning objectives, and so I'd like to briefly review them and how we're going to go about them. So what we'd like to do today is to review the relevance and the likelihood of linguistic discrepancies between evaluators and defendants in competency to stand trial evaluations. And we're going to apply the research that relates to language interpreters to this particular setting, and then review some psychological tests that can be used in this setting with individuals who are bilingual or speak a language other than English. The way that we'll go about this is first to provide the context of competency stand trial evaluations. I think that is really important, and I'll talk a little bit about why in just a few minutes. Then we'll talk about the likelihood of linguistic discrepancies. It is hard to quantify this variable, and we'll talk about why that is, and review some definitions of the linguistic spectrum. We'll again apply the knowledge around the use of interpreters and psychological measures and apply it to this particular setting. So I realize this is a very knowledgeable audience, and so I'm going to be fairly quick in covering generally competency to stand trial. This relates to the right that defendants facing criminal charges have to participate in their defense. It was extended to immigration court in 2001, and the criteria come from Dusky versus United States in 1960, and are defined as a rational and factual understanding of their case and an ability to work with an attorney. If someone is deemed incompetent, that they don't have these abilities, then they'll be referred for restoration services, and then there will be subsequent evaluations that take place to see whether or not they've achieved those abilities within the restoration services. The evaluation is similar across the country. Almost every state has adapted DUSCI to some degree, but the context differs. And so the context of these evaluations differ broadly across different areas. One of the reasons why they differ is the settings in which these evaluations take place varies. This can take place in a hospital, in a jail, inpatient, outpatient. The person who conducts these evaluations is also different because that's specified by state statute. So often states require a psychiatrist to conduct these evaluations, or a licensed psychologist. In a state like Connecticut, it's either a psychiatrist or there can be a team with a psychiatrist, a psychologist, a social worker, or a psychiatric nurse. In New York, it could be a psychiatrist or a psychologist. But again, it differs. The specific components of the evaluation can also differ. Although every state does incorporate the DUSCI criteria, according to state statutes, some states will require that the evaluators directly speak to the likelihood of restoration, that it could occur in the foreseeable future, that would occur in an inpatient or outpatient setting. There are states like Utah that have more details that are required according to state statute. In Utah, they actually ask that evaluators specifically speak to the likelihood of feigned or false symptoms. That's not the case in many other states. So this also leads to differences in the use of standardized measures across these evaluations. There have been a number of surveys, many of which are about 20 years old at this point, although the survey by Neal and Grisso is more recent in 2014. There's a wide variety in who is actually using standardized measures. And I do want to acknowledge that while the information is identified differently in Neal and Grisso's, they asked whether or not evaluators had used measures in the last two evaluations they had done. So some of those can go upwards of 58%. However, most of these surveys have focused on psychologists, despite attempts to reach psychiatrists from many of the researchers. But the focus on psychologists when these evaluations are not only done by psychologists has likely inflated the use of measures. In the context of research that I've done, I've read several hundred of these evaluations in New York, and standardized measures were only used about 5% of the time. So again, a lot of variety, but despite this variety, these evaluations are done frequently. It's called the most commonly conducted evaluation, and many researchers are still citing Bonney and Grisso, who are fantastic researchers. And this estimate of 60,000 evaluations per year was published in 2000. It was actually published in 2000 based on data sets from 1994 and a publication from 1992. My students tried to update this, looking at the most recent versions of those specific data sets to try, again, their own extrapolation, but an updated extrapolation. And using the most updated sets available, which was still 2006 and 2009, I believe, but we came up with 92,507. We also contacted every state and asked them for the past 10 years of referrals for competency to stand trial evaluations to see whether we could document this increase and to see where this stood across the country. The data is a mess. People were kind and tried to be helpful, but the way that this information is tracked differs entirely state to state. There isn't always one institution that collects it. It's sometimes compiled with other types of evaluation. Felonies and misdemeanors might be separated, might not be separated. Juveniles can be included. It's very messy. Lauren Coyce is doing great work in this area. And has conducted a similar study. She estimated about 130,000 of these evaluations take place every year now. It's in line with our very messy data that has shown that over a 10-year period, the amount of orders of initial restoration has at least doubled in numerous states, including Virginia and Kentucky. And that increase has been noted across the field. So both researchers and the media have referred to the competency crisis. The amount of orders are just exceeding state resources. There aren't the means to carefully and ethically conduct the evaluations and provide restoration services. The wait lists are growing. This has now been documented numerous times in numerous places, and many individuals will cite specific horrific cases. There's one man who got an evaluation, was referred for restoration, and ended up passing away while he's in jail. And the accusation had been stealing a hamburger and fries. So there's a huge need to address this. The delays are resulting in withheld liberty, withheld treatment. Neil Gowan-Smith does a lot of great work, both research and clinical work in this area. And he wrote that I firmly believe that delays associated with competency-related services represent a genuine moral crisis. And the reason why I wanted to start off here is to acknowledge that we're very aware that we are providing recommendations in a field or a portion of our field that is overwhelmed within the midst of a crisis. And so the hope here today is to provide some specific research, clinical practice, our experience, recommendations that can address one area to make some of these evaluations go a little bit more smoothly. Sorry. And we're specifically going to relate to multicultural competence within competency stand trial evaluations. This need, the need to responsibly, thoughtfully acknowledge the cultural relevance of our own background and the defendants in this case and how that relates to an evaluation is a requirement across our field. So this is within the APA ethical code. This is within the specialty guidelines for forensic psychology. This has been reiterated recently by the American Psychology and Law Practice Committee. There's a clear requirement from the mental health field that this is something that needs to be done. And recently, this need has specifically been echoed in competency stand trial evaluations within the legal field. So Bergkamp and colleagues did a really great summary of 2 legal cases from the Washington Supreme Court that directly relate to multicultural competence within competency stand trial evaluations. I'm not going to go into so much depth about the specific cases because the way the court treats the concepts is going to be a little bit more relevant for our purposes. But in this one case in 2012, there was a woman who was born in a refugee camp in Thailand, came to the country at a young age, was then accused of murder. Competency was raised. There was an evaluation that was conducted with standardized measures. Now, after she was convicted, then the defense appealed based on the fact that the competency stand trial evaluation was not multiculturally competent. So the courts are directly recognizing this need. And there's 2 things that I think are particularly relevant for our purposes about this case. One was that the court determined that in this particular case, because this woman was acculturated to English-speaking majority culture within the United States, then it wasn't necessarily impactful, although it was wrong. So just the fact that the court is really considering acculturation, I think is really important to note. Also, the court very clearly stated that multicultural competence is a need in this area. So a trial court could not properly accept the competency evaluation of an expert who refused to acknowledge the importance of cultural competency and who failed to reasonably account for cultural competency in his or her evaluation. So this need is being acknowledged in the legal arena as well. Now, another case is a little bit more relevant directly to what we're going to be talking about today because we'll be talking specifically about linguistic discrepancies. So this other case was more complicated from 2007. Competency was raised multiple times, so there were multiple different evaluators. And the first, well, it was actually the second time competency was raised, but the first evaluation that was conducted by a bilingual neuropsychologist who did not directly address the concept of competency, but did speak to the cognitive capacity of this particular defendant and provided some accommodations that would be helpful in this case. So later, there was another competency evaluation that was done after a verdict was in. Again, it was a complicated case, but the Washington Supreme Court then looked at the different evaluations when competency was raised as a potential problem in this case. And there were two things that are particularly interesting in the way that they evaluated the competency stand trial evaluations and evaluators. One, there was this preference given to the bilingual neuropsychologist with an acknowledgement of the degree to which this person had thought about multicultural competence and acknowledged that within the evaluation, even though the evaluation did not directly relate to competence to stand trial. When the court considered the three evaluations that had been done that did directly relate to competency to stand trial, then there's two areas that I think are really relevant here. One is, again, that they specifically thought about and criticized these evaluations for not engaging the defendant in a culturally appropriate fashion. And second, they specifically noted difficulties with the use of a language interpreter. So they wrote, it's apparent that the defendant struggled with the dynamic of being questioned through an interpreter. Those of us who've used an interpreter, I think, can hear that, especially loudly. We will talk about the use of an interpreter, provide some recommendations about ways in which it can be done more smoothly, but there are absolutely difficulties that arise in this, and they have been noticed by the court. Now, we're still in the context of needing to use interpreters, of there likely being linguistic discrepancies between evaluators and the defendants. This data is hard to quantify. There's a few reasons around this, and so I do want to very freely acknowledge that these are estimations and assumptions, and so still, from people's experiences, I think we can see that there is clearly a discrepancy that occurs. One statistic that's often cited when researchers and clinicians are trying to quantify the degree to which linguistic discrepancies would occur in this setting is by using the census data. The census data has the language use through the American Community Survey. And so through those surveys, then we can see generally, according to the US Census, that over 20% of the population that's over the age of 5 in the United States reports speaking language other than English at home, and 41% of that, sorry, that percentage speak English less than very well. There's no good data about this that we were able to find anyway, about language use and linguistic diversity within prison settings. But recent data from the federal prison system has shown that 15% of their individuals are not citizens and about a third are Hispanic. Clearly, that is gross exaggeration. We don't know what that means directly for who's using what language, but what it does speak to is a likelihood that we do have many individuals who are speaking languages other than English and may have limited English proficiency. And the language that arises frequently as a language other than English is Spanish. And because of that, we will be talking about an English to Spanish discrepancy relatively often throughout this presentation. What is clear is that there is increasing multilingual abilities within this country, and clinicians have not necessarily kept up. APA does do a regular survey asking clinicians about the languages that they speak and the languages that they provide services in, and it's been hovering around 10%. So about 10% of clinicians are providing or report providing services in a language other than English. Again, this does not directly apply, and we don't have data that really perfectly applies. So one issue is that psychiatrists are not included here, who are some of the individuals who are most frequently conducting competency to stand trial evaluations. And of course, it's not a representative sample. So it's not 10% of these clinicians, which means that 10% of individuals doing competency to stand trial evaluations are even providing services in a language other than English. But again, there's no reason to believe that the statistics look much better in this area. So given that we are likely to see frequent discrepancies, then Miriam is going to talk a little bit about the impact of those discrepancies on competency to stand trial evaluations.
We know that language, the language used during the evaluation and the linguistic background of the evaluee can impact a bunch of different things that may impact your competence to stand trial evaluation, such as self-reporting and the clinical judgments that you'll make. We know that language is tied to memory. An individual may recall more details or present as more emotional when they're being interviewed in a language in which the memory has occurred. This is especially important for this prison population that we're speaking of and individuals that are involved in the criminal legal system, because many of them have experienced trauma, and trauma can impact the emotionality that comes along with trauma may impact what they say to you or how they present during the evaluation. We also know that language can impact reporting of personality traits. So the cultural accommodation hypothesis by Bond and Yang in 1980 holds that multilinguals tend to accommodate the culture associated with the evaluation language. So for example, a non-native English speaker might endorse more values related to individualism when responding in English than in their native language. And this support for this cultural accommodation hypothesis is fairly strong. There's also preliminary evidence that language can impact ratings of symptom severity and decisions regarding whether or not to refer someone for a competence evaluation. So in 1998, Malgatti and Constantino interviewed 148 Hispanic clients with psychiatric diagnoses. They were interviewed in English, Spanish, or both, and they consistently found that Hispanic clinicians rated symptoms as more severe than white clinicians, and that regardless of the diagnosis or the clinician ethnicity, those that were interviewed in Spanish or in a bilingual modality were very consistently rated as having more severe symptoms than those who were interviewed in English. So this finding may represent that Spanish allows the participants to describe their actual severity of symptoms better, or it may mean that other cross-linguistic factors lead to over-pathologizing by clinicians of Spanish speakers. Varela and colleagues found that language factors impact attorney decisions to refer clients for competence to stand trial evaluations. So they asked 142 criminal defense attorneys to respond to a survey. In this survey, they read a vignette about a Hispanic defendant charged with assaults, and they were asked to rate the severity of the defendant's mental illness and the likelihood of referring him for competence evaluation. The vignettes varied in terms of whether the defendant spoke English or Spanish and whether the mental illness symptoms were obvious or ambiguous. Overall, attorneys rated Spanish-speaking defendant as less mentally ill than the English-speaking defendant, which is kind of interesting. The attorneys seem to under-pathologize where clinicians might be over-pathologizing. And they also found that the attorneys were less likely overall to refer the Spanish-speaking defendant for a competence to stand trial evaluation. These findings suggest attorneys were influenced by language, but we really need more research to understand the mechanism behind this influence. And lastly, there's preliminary evidence that interpreter use impacts evaluator decisions regarding competency. So a 2020 study by Murray and colleagues of about 2,600 CSP evaluations in Virginia found that only 1% of the reports were conducted in a language other than English, but they also found that evaluators were about twice as likely to opine that a defendant was incompetent when they used an interpreter. So this raises some concerns about the validity of forensic conclusions and evaluations with interpreters. And lastly, research has identified some language proficiency factors that could be misinterpreted as psychopathology. So a client with low proficiency in the language being used for the evaluation may exhibit behaviors like long pauses, maybe speech disturbance, less talking overall, a reduced ability to construct or maintain a coherent narrative, use of words that are out of context or inappropriate to the emotional context, and sometimes more body movements or nonverbal language that's related to increased cognitive demands in using a language they're not proficient in. So clearly there's some overlap between these language proficiency factors and some symptoms of both depression and psychotic disorders. So thinking about conducting an evaluation with any multilingual in the US, evaluating their language proficiency is going to be of the utmost importance and can help you make decisions regarding the most appropriate language for evaluation and possibly which tests to use. So I want to do a quick overview of kind of two different types of language proficiency that have been identified in the research. So on one hand, the left side, we have this basic interpersonal communication skills, or BICS. We like to think of this as like the top part of an iceberg. It's the skills that are used in high context social interactions. They're used with high frequency vocabulary. They tend to have a pretty simple sentence structure. And research shows that BICS is developed early on in learning a new language. It takes about 1 to 2 years. And these skills are used generally in like low pressure situations, like greeting someone, talking about what your likes and dislikes are, or like simple planning, making an appointment with someone. And these skills, BICS, are separate from cognitive academic language proficiency, or CALP. So this is what we think of as the bottom of the iceberg, kind of the bigger portion of language proficiency that takes longer to achieve. So CALP is the skills that are used in context-reduced professional and educational activities. I would argue that CALP is what's needed to perform well in a psychological evaluation where context is very reduced and high pressure. So CALP includes the low frequency vocabulary that's more abstract. It's developed later, approximately 5 to 7 years after being exposed and learning a new language. And it's generally high stakes. There's a lot more pressure. So for example, forming arguments, using humor, understanding idioms, and really specialized terminology that is very frequently used in the criminal legal system and in these CST evaluations. So there's no gold standard for how to determine what is the best language to conduct an evaluation. And there's no gold standard for determining bilingualism in research or clinical practice. If you look in the research, you'll find many different definitions of bilingualism. And unfortunately, it makes it really hard to compare results across studies because of this lack of clarity. So language and social background characteristics that you should consider that can inform testing decisions: sequential versus simultaneous bilingualism. Simultaneous is when someone is learning 2 languages at the same time. They're often learning both languages since birth. And simultaneous bilinguals tend to have a more balanced language profile and show greater proficiency in each language. You also have sequential bilinguals. You learn one language first, and then later on, you're learning another language. This would include adult language learners, or someone who learns a language during college or afterwards. And sequential bilinguals frequently have more unbalanced language proficiency. They tend to favor one language over another. You want to consider the frequency and diversity of language use. How often are they using this language? Are they using it just at home? Are they using it at school? Are they using it in medical appointments? What kinds of vocabulary are they frequently exposed to? You also want to consider their cultural immersion. And oftentimes for us, this is length of time that they've spent in the United States. And this is related to another important variable of acculturation, knowing how much they kind of subscribe to US norms and US values, which we know also impacts the results of assessments. Language of academic instruction may be one of the most important variables to consider. Again, going back to the cognitive academic language proficiency, if someone has received most of their academics in English, you can pretty reasonably assume that they would have cognitive academic language proficiency, although I'll stick with formal evaluation of language proficiency is always the best way to go. And then lastly, we want to consider like language proficiency and balance, which I already discussed. So these factors are most relevant when you're initially trying to determine an appropriate testing language. But when English is not appropriate and a referral to a multilingual clinician is not available, that's when you would think about using an interpreter.
So I have a lot to say about the use of interpreters. We could easily spend a lot of time here, but I'm going to try to be as concise as possible because my current research is looking at the use of interpreters in mental health settings. Now, it's not surprising, given the nature of evaluations, of psychological evaluations, or emphasis on communication, verbal and nonverbal communication, that the use of interpreters can be fraught. The use of interpreters can be associated with more errors, with less disclosure, with misdiagnosis. And that still being said, there can be benefits to use an interpreter, especially when it's used in a thoughtful context, when everybody is working together within this. That's part of the reason why trained interpreters can reduce errors. That is a generalized term. And I would love to talk about the different types of interpreters, which you don't kind of have the space to do today, of the phone versus remote versus in person. But I imagine many individuals here are familiar with court-trained interpreters, of court-certified interpreters, which is one area of training that can be really relevant here. Still, on the next slide, we're going to talk about having meetings with an interpreter before and after an evaluation. And even a court-trained interpreter may not have training with this particular type of evaluation. Similarly, they may not have experience in mental health settings. And that is one thing that I am working on with Professor Martinez Gomez to create a program. We're just in the first stages of this, an empirically supported program that will train interpreters to work in mental health settings. And the use of training really can reduce these errors. The more knowledge we have about the expectations everyone has walking into the room, I think the more helpful this is going to be. And there was one role, we'll talk about the idea of using an interpreter as a cultural broker in the next slide. But first, I want to relate to a different type of role that interpreters may act within. And this really comes from my colleague who specializes in interpretation studies and was conducting a different research study looking at interpretation outside of psychological settings in prison. And there were bilingual individuals in prison who were serving as interpreters for fellow inmates. And there were a few that were highly desirable, that individuals wanted them to serve as their interpreter. And when she looked at the quality of the interpretation, then one of the things she found was that these individuals were not blindly interpreting what each person was saying. They were acting as an advocate within that role, and that was an expected role within the prison. It was known that there were some interpreters who would help. They would help convey not just what you were saying, but how to say it well in a way that would be helpful for your case. And this role extends beyond prison to very different settings. There's actually some research that's coming out in pediatric oncology that's looking at the role of interpreters. And from the perspective of both interpreters and patients, similarly, there's this expectation that an interpreter is going to also be an advocate. So in addition to helping clarify the situation, they're actually going to help promote benefits. Now, there are concerns with using an interpreter in this role within psychological settings. Clearly, it's very important that we understand the information and the limits of understanding within a psychological setting. However, I still think it's very important to understand expectations, and there is at least the possibility. I do not know the degree to which this actually relates to competency trial settings, but I think it's important to start to think about it, because there's at least the risk that when people come into the room with this evaluation, if we hold fast to our ethical guidelines, that could actually be seen as taking away one avenue of advocacy for a client. And we definitely want to clarify that role with an interpreter. If they do see their role as an advocate, then we need to talk about what we need from them very clearly. Okay, so again, we'll talk about these conversations with interpreters, but before we go there, I want to briefly talk about the logistics of seating arrangements. And again, a caveat here, I've done evaluations in hospital settings and prison settings. I realize we don't always have the luxury of arranging a room however we'd like. But that being said, when you do have some freedom, there's two different seating patterns that are talked a lot about with interpreters: triangulated seating and parallel seating. So you could see triangulated seating really emphasizes the role of the interpreter as kind of an equal role within this evaluation. And so it's interpreter, defendant, and clinician. Within parallel seating, then the emphasis is on the relationship between the defendant and the clinician, and then the interpreter is off to the side. So there are some clinicians who prefer the parallel seating because they want to be the authority and they feel like they can get, they can develop that relationship with the defendant when the interpreter is off to the side. When you think about these types of arrangements in competency stand trial, I just want you to take a moment to consider what it feels like to have somebody right behind you who's talking. It can be a little bit uncomfortable for many of us, and given the paranoia that can be in the room, the fact that psychotic symptoms tend to be more likely within these evaluations, I just want to be thoughtful about making choices that would likely increase feelings of paranoia, perhaps even in an artificial way. So I would recommend the triangulated seating in this context, both to avoid that feeling of paranoia, but also because it can be helpful to utilize the interpreter within this evaluation. The way to do that is to include them, to fully include them. So you would want to meet with them before and after the evaluation. Again, I realize whenever this is possible. And this preempts one of the problems that's commonly reported in the use of an interpreter. Then, clinicians and interpreters have both reported that interpreters can feel unprepared for the content. And so we can prepare them for the content, right? One, I think transparency is generally best whenever we can, and we can clearly acknowledge the goals of the evaluation. This also addresses the point in the previous slide of the degree to which an interpreter might feel that they need to advocate for someone to help clarify. That feeling of helping to clarify information can be directly problematic in competency stand trial when we are actually trying to figure out the limits of somebody's understanding. So we need to know what's happening between all parties so we can understand whether the defendant really understands the roles of the court, or whether they got additional help kind of from the interpreter. And so it's important that the interpreter understands what we're doing, why we're doing it, and that we want to know about the word choice of a client. We want to know if something was awkwardly phrased. We want to know if the chosen word didn't make sense within the context. It's also really important to acknowledge the possible trauma. So again, even a court certified interpreter doesn't necessarily have experience in mental health settings, and it can be really beneficial just to acknowledge that the content may tangentially be traumatic, be violent, and there's the possibility for psychotic symptoms that could be surprising. And so to give them a chance to answer any questions. Especially after COVID, I'm always a little bit hesitant of asking more of anyone because everybody is burnt out in this context. But I can tell you, at least from the research that we've been doing with interpreters, it's been, for a lot of our research assistants, the most wonderful group. We've been talking with interpreters who've worked in mental health settings, with monolingual clients who've worked with interpreters, and with clinicians who have utilized interpreters in mental health settings. And the interpreters are so happy to be there. Like, they wanted this information to say that it can be overwhelming, that they're expected to operate in this system and they're not provided enough information about how to do their job well. So I think this can be collaborative and then enhance the rapport with everybody involved. It's also important to have really clear conversations about what you're looking for in an interpreter in this setting. There are different ways to interpret, like the difference between simultaneous or sequential interpreting. Sometimes interpreters can interpret while you're speaking. Think about what you would see if you've ever watched a UN session. I would recommend in this context sequential interpreting, which would be you speak, you stop speaking, the interpreter speaks. It allows for a little bit more of back and forth. I think it can be helpful to encourage the interpreter to let you know if what you've said does not translate well. And one of the criticisms has been that interpreters will sometimes change the nature of a question. So an open question can become closed, or a closed question can become open. So first, that would be important to acknowledge that you would like it to remain consistent. And at the same time, sometimes the nature of the question changes because it didn't translate well. So it was an attempt to maintain the relevance of that question. So again, it can be just very important to acknowledge these differences and encourage the interpreter to let you know what's happening, what problems might be occurring before. And to be very transparent, which I know I'm going to come back to in a few points, but with the defendant as well. Because again, that can induce paranoia whenever you have conversations that are happening in another language. If you don't actually understand what's happening, there's no reason to hide what's happening. You can talk to the defendant and the interpreter to say that you want this information to be clear. You want to understand their understanding of their situation. And so if anything is unclear, then you'd like them to stop and ask you a question. And if, for instance, the clinician, the interpreter have a brief conversation about the best way to ask a question, you can tell the defendant directly, this is what we just spoke about, right? There's no reason to hide that information. It's also very important to thoughtfully differentiate between linguistic and cultural interpreters or cultural brokers. This is one possible resource. So it's also important to let the interpreter know that you would love to get their expertise after the session about anything that they noticed and thought. They may catch things that you miss in terms of what would be culturally appropriate, what would be culturally inappropriate, pauses, nonverbal gestures, anything that they would notice that would be unusual can be helpful information. And at the same time, the fact that two people share a linguistic background does not mean that they share a cultural background. And so it's also very important to acknowledge that and find out from your interpreter what their background is. We have multiple pieces of information, and we always want to look at the strengths and the weaknesses and the limitations of each of those pieces of information. Okay, and again, consistently, I just think it's important to emphasize transparency in these settings. There's a few things that we can do as well to try to minimize the miscommunication that can occur, to use clear, concise language, beware of jargon. I realize that there's a need to use legal jargon in the context of this evaluation, but we can minimize psychological jargon. And again, to encourage questions, even within the evaluation, to be ready to learn to do it better. And that being said, we want to go to a different area of the use of measures in these evaluations.
I want to acknowledge that not everyone uses psychological measures during a CST evaluation. Recently, Virginia implemented like a oversight board of forensic evaluations for competence to stand trial. So there's a 2020 study that looked at 3,600 CST evaluations in Virginia from 126 individual evaluators. And they found that about 1/3 of the individual evaluators said they used testing in at least one report. But that overall very few reports in Virginia, only about 5% indicated testing was completed. So when testing is completed, intelligence testing is the most commonly cited used test, followed by specific tests of effort and pain symptoms, and then personality testing, and lastly, forensic instruments that are specific to competence to stand trial. So if testing is being used, we need to consider the language background and a couple of different things in selecting the testing battery. So first is the consideration of norms when you're using any standardized assessments, such as the Weiss 4 that I'll talk more about on the next slide. While this may seem obvious, a dissertation in 2014 found that 59% of psychologists that they interviewed, a total of 70, that were evaluating CST with Spanish-speaking clients reported they used a competency measure. So more than half used the measure, but at the same time, 65% of those did not know if the assessment had been normed on a Spanish sample. So it shows that we do really need to highlight this consideration of norms as crucial to selecting your testing battery. So unfortunately, a lot of standardized tests exclude bilinguals and individuals with limited English proficiency from their normative sample. But when they are available, norms from US residing bilinguals would be the most appropriate. A 2021 survey of Spanish-speaking neuropsychologists found that the bilingual US norms were the most commonly used, followed by norms from someone's country of origin, and then lastly by monolingual US norms. So when using norms from a country of origin or somewhere really close, for example, maybe you have an evaluee from Peru and you decide to use the Colombian norms. But make sure to consider accent and dialect. We know that Spanish is not like this monolith, and there's a wide variation of cultural experience and linguistic backgrounds among US residing Spanish speakers. So consideration of the extent of reliance on language of the individual measures that you use is also really important. Reading level, oral comprehension, and oral fluency are all separate aspects of language proficiency, and they may not be developed equally in all languages that the person uses. So many US-born Spanish speakers have oral fluency in a language. They use it at home and with their family every day, but they've never received schooling in Spanish. And therefore their reading level and their ability to write may actually be a lot lower than their ability to speak or understand orally. So it's important to consider their reading level separate from their oral fluency. And in addition, a lot of people recommend using nonverbal tests with someone who is non-English speaking or limited English proficient. But as we know, nonverbal tests frequently require some portion of verbal comprehension, whether that just be explaining what the test is to them in the instructions. They still need to have oral comprehension in order to complete some nonverbal tests. And then lastly, we want to consider specificity rates, especially when a test has not been normed on a bilingual sample. So we generally see higher failure rates for bilinguals and Spanish speakers on tests of performance validity in other languages. And even if this difference is not statistically significant, which sometimes it's not in the research, it may still be clinically significant and have an impact on the clinical opinion regarding competency. So really important to consider differences in general classification rates and total scores that you might see when testing bilinguals compared to monolingual. I'll talk a little bit about using the Weiss score with Spanish speakers because we actually do have a number of options. Unfortunately, most of the prior research examining how language impacts scores on the Weiss really focuses on the Weiss R and the Weiss 3, which are both out of print for many years at this point, and yet there's still research being published this year on use of the Weiss 3 with bilinguals. So we have, of course, the Weiss 4, the English version, developed in 2008, and this one was normed on monolingual English speakers in the US. So huge caution against using those norms with bilinguals. You could underestimate ability or overestimate impairment. Bilinguals, we know, perform differently on certain subtests, particularly subtests related to working memory and processing speed. So those are the two areas where you might see language impacting scores most heavily. And then there's 4 different translations of the Weiss 4. And just to note that all of them, the initial translation was into Spain Spanish, and then all of the remaining translations were adapted from the Spain Spanish version. At this point, these versions tend to have fairly good reliability and validity, but it's also important, again, to consider the norms, who was in the sample, and how many there were. So the Spain Spanish translation had about 1,000 people in the normative sample compared to the Weiss 4, which had more than 2,000. The Mexican Spanish translation and norms are frequently used in the US since the majority of Spanish speakers in the US have some sort of Mexican descent or origin. But interestingly, I recently had to obtain the Weiss 4 and the Mexican Spanish translation of the Weiss 4 for my research study, and it was really hard to figure out how to order it, who do I ask for, how much it costs. And then when I actually received it, I noticed everything was of a lower quality in the Weiss 4 in English. So getting access to these tests is actually a little bit harder than you might think. Then we also have a Chilean translation and norms. It's normed on 887 Chileans. This one, no idea how to get access to it. You can find research studies that have used it. I have no idea how to purchase the Chilean translation. And similarly for the Colombian translation and norms, which came out in 2016, it's unclear to where to purchase. And it's really important to note that the normative sample was only 156 individuals. They did not report race or socioeconomic status of these individuals. And we know that socioeconomic status and education level is an important predictor of score differences. And so I would highly caution on using the Colombian translation and norms just because we don't know if it was a representative sample and we don't really know how well it represents them. So overall, we must be very careful around which Weiss 4 version we're using. due to the wide range of cultural and linguistic backgrounds present among the US residing Spanish speakers we evaluate.
So we realize that cognitive evaluations or cognitive measures are used most often when measures are used, but we're going to very briefly cover a few different areas. So I first want to acknowledge there is more research on performance validity measures, specifically the Spanish versions of them. However, within competency stand trial evaluation, then because psychosis is often a factor, then feigned psychosis is often a question. And so I'm going to briefly talk about the SIRS-2, the Structured Interview for Reported Symptoms, which is frequently used. Unlike, as Miriam stated, some of the Weiss translations, the SIRS-2 is readily available in Spanish from the publisher, so you can buy it. It has the same norms, though, as the English version, and there is some research that is limited that does support the use of the SIRS in Spanish samples. We use this in my research lab, but we're running low on time, so I'm happy to answer some of those questions if anyone has them after the fact. But I would say that there has been anecdotally a lot of bilingual clinicians who have told me about concerns using the SIRS, of feeling as if their clients don't fully understand the questions. Not so surprising when we're asking someone questions that may or may not apply to them about obscure psychotic symptoms. It's still really important to consider reading level, education, acculturation, and CALP when we administer these measures. And briefly, I also want to just acknowledge the forensic measures that were developed specifically for competency to stand trial. They exist, as Anderson and colleagues wrote, I think just in 2022, that despite the fact that the field has a fairly positive view of many of these measures, it does seem like they're not used very frequently. When it comes to the use of these measures in individuals who speak a language other than English, that's probably a good thing. I could not figure out whether or not there's any language other than English that's available for purchase. Again, probably a good thing because there's no research. So first, we need to conduct research to see whether or not this is a viable means of evaluating clients who speak, or defendants who speak a language other than English, because perhaps this could be an accurate way to get a standardized measure within the context of these evaluations. But again, we are at the very first stage here. There absolutely needs to be research done. So closing recommendations before we have some questions. For all of this, it would be ideal to have a trained bilingual evaluator, to not have to worry about the use of an interpreter, to have measures that have been developed specifically for a sample that represents the defendant in front of you, but that's not always the case. And so when it's not the case, then it's important to carefully evaluate linguistic ability. Again, not a categorical variable. Think about your own knowledge of any other languages. There's a fact. Right, CALP, BICS are very real variables, even for us, that we need to understand what is our knowledge. Are we able to conduct ourselves professionally in this language or not? And then to evaluate the need for referral versus the use of an interpreter. And when you do choose to use an interpreter, then they can be really thoughtfully engaged. And measures, again, can be very carefully chosen. And I also just want to acknowledge that there has been research that has shown that, especially when it comes to psychological tools, they're very rarely challenged in court. And so it shows that the burden of this, of conducting ethical evaluations efficiently within the context, really is on us as clinicians. So thank you so much for having us, for letting us give little spiels about some of the things that we're working on. It was great to be here, and we will stick around for a few minutes for questions.
Yes, thank you so much, Rebecca, Miriam, for that very, very thorough and multifaceted information on when these linguistic barriers can come up during competency evaluations and the things we might have to consider in those circumstances. We have several questions here. I'll do my best to get through some of them. And then also in the meantime, for those of you that still have questions for our presenters, we're getting to the top of the hour, but they can stay on for a little bit. And you can enter any questions that you have in the Q&A box. We'll do the best that we can to get to a few of these. Somebody asked, they were wondering if you had any thoughts on working with clients who have limited English proficiency, but speak a language without interpreters readily available. This person gives an example of an indigenous language where there are very few speakers at all, let alone somebody that's in the court.
Yeah, I'm actually glad that came up because that happens a lot with Spanish, right? So there's often individuals who will speak Spanish as a second or third language when their first language is an indigenous language. That I think, first of all, the fact of just being aware of that situation rather than just saying that someone is a Spanish speaker is already crucial and incredibly important. And this is also another point about using interpreters. Of course, we want a trained interpreter, but especially in languages that are less frequently spoken, it is important to also evaluate whether there is a relationship between the interpreter and the person in front of you, the defendant or your client, just because it can be, someone may come from a small community. And so you want to know if there are multiple relationships that could play a role in the evaluation as well. But I think all the same other factors apply to then really consider the importance of CALP and BICS become very relevant there of in either way. It may be that someone spoke an indigenous language at home, but actually went to school in Spanish, in which case Spanish may be an ideal language for a cognitive test. But all those external factors would be really relevant. Miriam, do you have thoughts about that too?
Yeah, just similarly to what you said, I did an evaluation last year that was a client who spoke a native indigenous language from Guatemala. Spanish and English were her second and third languages, and frequently we're just without options. So being really conscious of like different cultural values and showing curiosity during the evaluation, I think really went a long way in terms of resolving some of those linguistic discrepancies. But yeah, unfortunately, you just don't always have access to it.
Yeah, and being transparent about any limitations you see.
Absolutely, thank you. Both of you referenced some unique circumstances in Spanish speaking, and then Miriam, in fact, in your example right there, you brought up the Guatemalan language. Somebody asked as context that they're an attorney director of a center that supports attorneys in child and family welfare cases, and said in New Mexico, some of their local psychologists may fluently speak a colonial origin Spanish that's evolved with English influence. Would a person from, say, Guatemala, Mexico, Chile, et cetera, benefit from an interpreter in this circumstance? Or perhaps how would you consider, if somebody comes from a language with quote unquote Spanish speaking, how you would determine whether an interpreter would be beneficial?
The difference in dialects can be really considerable. Miriam, I think Miriam has been conducting research and she has RAs who all speak Spanish from different areas of the world. But I think your expertise is very relevant here.
Yeah, I think there's just so many different language background characteristics to be curious about here. First, I would say to like thoroughly evaluate those and to ask the person, like, what are some of the main differences between the dialect that you speak and maybe a more common or more readily available dialect. In my experience, often people will move forward with an evaluation, even if there are dialect differences. And in my experience working with our RAs, who are, like Rebecca said, of varying different dialects and cultural origins, who are also working with our research participants who are similarly of varying dialect and cultural origins, we're often able to resolve linguistic discrepancies during the evaluation and during the testing. Of course, it's going against standardization, especially talking about the Weiss score, which we're administering, but being transparent about those differences where you were, straying from standardization and the rationale behind straying from that standardization can be really useful. So I would say most of the time, I don't think an interpreter is needed in that case because there are so many shared and common origins across these dialects. But ultimately, I would ask the person in the beginning of the evaluation when you're speaking with them in Spanish, like try to do some sort of check for understanding and ask them, like, would you like to have an interpreter present? That might help out there.
Yeah, and I'd say also afterwards to have that follow-up conversation to ask the interpreter about differences that they perceived. And you can have a feedback session with your client or the defendant afterwards to ask whether they felt like they were understood.
Wonderful. Yes, that post feedback can be very crucial. Thank you. Someone asked if you had any advice when the charge itself might not translate. So for example, they said, for example, had a recent case where the defendant was charged with maiming and the Spanish speaking interpreter had trouble translating the charge name. How you would proceed in that situation?
That is really, it is difficult. And I've had some similar circumstances as well. I think you have to go about this. First of all, it's an example of somebody who even has, court certification does not necessarily have all of the vocabulary for every possible charge. There are absolutely things that can come about. And I think one of the things that my first instinct with that example would be worry that elaboration about that charge is also going to hurt rapport. Like you're just by default going into depth about something more gruesome, which can occur. But I think you have to speak with clarity, and when you approach it in a non-judgmental way, then I think you can overcome those difficulties to the best degree possible. And again, just acknowledge them. We're not going to be able to solve all of these, but we do need to acknowledge what occurred and what we did about it. So to acknowledge that the interpreter had difficulty here, to ensure that the defendant understands, because I imagine with that circumstance, the defendant was asking, saying, I don't understand what this means. And so to continue the conversation until the concept is understood, and then to acknowledge that that conversation occurred.
Wonderful. Thank you. Someone said you mentioned some pros and cons with the EIWA. Curious about your thoughts on nonverbal assessment of cognitive functioning or intellect, like the TONI or the C-TONI, especially for those who speak a language other than English and Spanish.
Yeah, that, I think we need more research here, but there is some research that has shown differences in the use of nonverbal tests versus tests. But what I would love to see is a really well done study that could then compare the use of a nonverbal versus the use of a verbal test through an interpreter versus the use of a translated test. I think that would be really helpful. The fact is, when you're talking about a language other than English and Spanish, you don't always have the options. So sometimes that's what exists, but then you need to consider the normative data. How well does that reflect on your particular client? Another thing that I want to throw in there, we didn't remotely have time, but another grad student who works with us often is fluent in American Sign Language. And so that's another area where people often use nonverbal tests, but you have to think about the fact that some dialects of sign language use two hands, and so that can also impact testing. But the fact is, I wish I could give a clear answer of what would be best, but I don't think there is one. I think that you're going to have limitations of a test that has very little research in the language in which you're using it, regardless. So if you have the ability of translation versus nonverbal, you're going to have to go with one, but very clearly acknowledge. And when you acknowledge limitations, be really thoughtful about whether you think it might be underestimated or overestimated. And when it comes to competency stand trial, this is often, we can acknowledge these faults and then directly consider whether or not it would impact the actual result, right? To then say that maybe this is a classification range, and still, if the range is within the standard degree of error, would that actually impact somebody's level of competence?
Wonderful. Thank you. One last question here before we wrap up. Someone noted that they have to do competency evals with developmentally disabled individuals who are monolingual Spanish speakers, and they were asking for any suggestions that you have on measures to use. They use the FIT, the CAST ID, and a malingering measure. But for this particular intersection of Spanish speaking and developmental disability, any particular recommendations?
That is rough. It is. I think, honestly, I feel like we need more research to help you in that area, because already there's research that looks at the use of some of these measures with populations with ADHD or lower levels of education, and we're seeing some concerns. And so when you multiply all of the potential confounding variables, it can be problematic. I think if anything, then it would be important to use the tools and also clinical expertise, and then to think about how all of these different flawed tools play out together. But I'm going to think about that, and you can send me an email to say, and I'll talk to my colleague if there's one in particular that might be helpful in that context.
Well, thank you so much, Rebecca, Miriam, for this very helpful topic. This intersects with a lot of people's practice here across the country and across the globe, because we have a lot of different global representation here. Much appreciated you sharing all of your firsthand knowledge and expertise here with us on this issue. That wraps up this week's Law and Mental Health series. We hope to see you next week when Dr. Robin Wilson will be covering understanding special needs for people with in forensic mental health assessment. Until then, have a fantastic rest of the week, and we hope to see you again soon.